We'll hear argument first this morning in Rapanos versus United States and Carabel versus United States Army Corps of Engineers. Mr. Hopper.
Mr. Chief Justice, may it please the Court, this is a case of agency overreaching. In this case, the Corps and EPA pushed the very limits of congressional authority, contrary to the plain text of the Act and without any clear indication Congress intended that result. They claim 404A jurisdiction over the entire tributary system, from the smallest trickle to the largest watershed, sweeping in remote, non-navigable wetlands 20 miles from a traditional navigable water. This limitless claim of jurisdiction shifts the federal-state balance and raises significant constitutional questions. We believe this boundless interpretation is inconsistent with this Court's reading of the Act in Solid Waste Agency.
It goes somewhat beyond the smallest trickle, doesn't it? Doesn't it also include ditches that currently don't have any trickle if they obtain a trickle during a rainstorm?
Yes, Your Honor. They actually argue that it makes no difference whether what the substantiality is or the directness of the connection is. It's irrelevant to the jurisdictional determination.
So where would you put the line?
I put the line where Congress put the line, Your Honor. Congress declared in 404A that it would prohibit the discharge of fill and dredge material into the navigable waters.
Well, it seems to me that what works in your favor is it Swank? I'm not quite sure how to pronounce the case. The migratory bird rule case, where we said there had to be a significant nexus. But I think what the Court's asking you is how to define significant nexus. If you want us just to say, well, this case is too much, but then the Corps of Engineers should use its expertise to come up with a new regulation, that's rather an odd opinion for us to write.
Well, this
and
Court
it
did
seems
not.
to me that that's what you're asking us to do here.
This Court did not suggest in Swank that a significant nexus constitutes the jurisdictional standard for all waters. If there are no further questions, I'd like to reserve my time.
General Clement.
Mr. Chief Justice, and may it please the Court, in United States against Riverside Bayview Homes, this Court unanimously upheld the Corps' jurisdiction over wetlands that were not themselves navigable but were adjacent to waters otherwise within the Corps' jurisdiction. The principal difference between the Rapanos wetlands and the wetlands at issue in Riverside Bayview are that the Rapanos wetlands are adjacent to a non-navigable tributary, while the wetlands at issue in Riverside Bayview were adjacent to a navigable creek.
How do you define tributary?
Mr.
Tributary, you say they're adjacent to a non-navigable tributary. It's a culvert, a ditch, right?
Well, not in all these cases, Mr. Chief
But in
Justice.
Rapanos' case.
No, that's actually not true. There are three specific wetlands that are at issue in the Rapanos case. One of those, the Pine River site, as its name suggests, is adjacent to the Pine River, which is a body of water that has water flowing through it all year round. It's a river. I don't think anybody would look at that and say that's not a tributary of the downstream navigable rivers. And I think that's why in
We're calling empty ditches, no, not unless you call empty ditches land, which I do.
Well, the Corps doesn't. They treat those as water bodies, and that's not the gravamen of the complaint.
But your theory is that there is regulatory authority because there's an interaction between the wetlands or the lands in question and the navigable waters.
Justice Kennedy, that's not precisely accurate.